Welcome to today's webinar, SCOTUS Redistricting Cases, brought to you by NCSL. It is now my pleasure to turn the floor over to Lisa Sornin. The floor is yours.
Hi, everyone, and welcome again to the State Local Legal Center's webinar on Supreme Court redistricting cases. Again, I'm Lisa Sornin, Executive Director of the State and Local Legal Center. A few housekeeping matters before we begin. First, I'd like to thank the National Conference of State Legislatures for hosting this call. During the presentation, you can ask questions by typing them in the chat box. I will read the questions at the end of the speakers. The handout and a copy of the PowerPoint are available in the right-hand corner in the media library. A recording of this webinar will be available on the State and Local Legal Center's website and NCSL's website following the webinar. The views expressed in this webinar do not necessarily reflect the views of NCSL or the other SLLC member groups. For those of you who are new to the State and Local Legal Center, the SLLC files amicus briefs before the United States Supreme Court on behalf of its members, comprised of the Big Seven national organizations representing the interests of state and local governments. These groups and the SLLC's 2 associate members are listed on this slide. Since 1983, the SLLC has filed over 300 Supreme Court amicus briefs. This term, the SLLC filed 7. The SLLC is also a resource for Big Seven members on the Supreme Court, and this webinar is an example. I will now introduce our speakers. Professor Rick Hasen of the University of California, Irvine will provide an overview of redistricting law as it relates to the case discussed in this webinar. The professor is a nationally recognized expert in elections law and campaign finance regulation and is co-author of a leading casebook on election law. Mark Packman, Gilbert LLP, wrote NCSL's Supreme Court amicus brief in the 2014 Supreme Court case of Arizona State Legislature versus Arizona Independent Redistricting Commission, holding that legislatures may be excluded entirely from the redistricting process. Bruce Adelson, Federal Compliance Consultant, is a former U.S. DOJ voting section senior trial attorney. He also was a consulting DRA expert in Harris versus Arizona Independent Redistricting Commission involving the constitutionality of Arizona's 2010 redistricting plan, decided this term. Professor Hasen, you may begin.
Thanks very much. It's a pleasure to be with all of you, and my job is just to set the stage for the other speakers to talk more specifically about the cases that have come to the Supreme Court this term in the area of redistricting. Let me just start with the question of why redistricting. Why do we see these cases all the time? Why is it that we're more than halfway through the decade and there's still so many cases? First, to begin, redistricting is required every 10 years after new census numbers come out for any elections that are held in districts. So that could be for Congress, for state or local legislative bodies. No redistricting required for single-member offices, like the office of governor. There are no districts, or legislative bodies that are elected at large, where there's no districting. And the lines have to be drawn for these districts in state, local, and congressional elections using districts after each census, thanks to the Supreme Court's one-person, one-vote cases, which date back to the 1960s, beginning with cases such as Baker versus Carr, Reynolds versus Sims, and Westbury versus Sanders. These cases require that districts contain roughly equal numbers of people or voters, and I think we'll be talking about the specifics of what the denominator is as we go further. What standards do people have to apply when they're drawing district lines? Well, first, all redistricting must comply with the one-person, one-vote standard, although that standard has been different whether we're talking about congressional redistricting, where the standard has been stricter in terms of how much you can deviate from perfect equality, or state or local redistricting. In addition, all redistricting has to comply with Section 2 of the Voting Rights Act, which assures that members of protected minority groups have the same opportunity as others to participate in the political process and to elect representatives of their choice. So in areas where there is a substantial minority population, it is possible that a redistricting plan would be challenged as diluting the vote of minority voters. This is known as a vote dilution kind of claim. Now, although the Voting Rights Act requires that redistricting authorities take race into account when drawing district lines, if race is taken too much into account in drawing district lines, then the redistricting authorities might be engaged in what has come to be known as an unconstitutional racial gerrymander in violation of the U.S. Constitution's Equal Protection Clause. And here the harm is not vote dilution, but instead what the court has described as the expressive harm of sending a message that government is separating people on the basis of race without adequate justification. So it puts redistricting authorities in a tough spot. They don't take race enough into account. They could face a Voting Rights Act challenge. If they take race too much into account, they could face a racial gerrymandering challenge. Finally, although the Supreme Court has said that partisan gerrymandering could well be unconstitutional, the court has never agreed on a standard for policing partisan gerrymandering. And Justice Kennedy, the justice in the middle in this series of cases on partisan gerrymandering, has left the door open. Although he's rejected earlier standards that have been proposed to decide when taking party into account too much would be unconstitutional, he has left open the possibility that litigants could come up with new standards to try to raise a partisan gerrymandering claim. And there are a few cases that are working their way up from the lower courts that could end up back at the Supreme Court on the question of whether there is such a standard. Aside from meeting all of these federal requirements, and everything I've discussed comes either from the U.S. Constitution or from federal statutes, there are also state requirements as well. These might include compactness, contiguity, complying with municipal and state boundaries, keeping communities of interest together. And these are state-specific requirements, and those you would have to consult the specific state constitution or state statutes to know what is required under state redistricting authorities. Now, when drawing district lines, what is it that redistricting authorities care about? Well, if redistricting is done by a political body, such as by a state legislature, the goal of redistricting is often to gain partisan advantage, Democrats drawing lines to help elect more Democrats, Republicans drawing lines to help elect more Republicans, and protecting incumbents. We sometimes see situations where lines are drawn to preserve the status quo. The goal that many political bodies try to achieve is to get to these political goals while avoiding successful legal challenge under the U.S. Constitution, under the Voting Rights Act, and under state law. Nonpartisan commissions, and we have those in some states, may have other goals, and those goals might be written into the charge of the nonpartisan commission, such as promoting political competition or prohibiting consideration of political considerations when drawing lines, and again, all while avoiding successful legal challenge. So while political and non-political forces might have different views as to what they're really trying to achieve, I think there is universal agreement that you don't want to be successfully sued for your redistricting plan. Nonetheless, as I said at the beginning, when we are now more than halfway through the decade, we still see a large number of redistricting suits that are still working their way through the process. And with that, I will turn it over to Mark.
Thanks very much, Rick. And I want to also thank Lisa and Tricia and their organizations for inviting me and putting this on. And I see in the chat room already a bunch of names I recognize. And hello to all those folks. Good to talk to you again. Let me start off with the Evenwel case, if I might. And because I think this one has some interesting implications for redistricting down the road. The facts of Evenwel you're probably all familiar with. Texas apportions its state Senate seats based on actual population, like everyone else, and they come up with a plan following the last census, with a deviation of a little over 8%. And what happens there is that you take the percentage by which the least populous district deviates from the ideal, and the percentage by which the most populous district deviates from the ideal, and you add them together. In this case, it came up as a little over 8%, as I say. Now, in Texas, as I'm sure all of you know, Texas has a substantial non-citizen population, and that is obviously a factor both politically and from a redistricting standpoint. And the plaintiffs brought a suit in a three-judge district court in Texas saying, look, this plan violates the Equal Protection Clause because the districts may have equal numbers of people, but they have unequal numbers of voters. The district court dismisses their claim, and the plaintiffs appeal to the Supreme Court. It's a direct appeal from the three-judge federal district court directly to the U.S. Supreme Court. And they repeat their argument that each district has to have an equal number of eligible voters. That is to say, they have to be citizens and they have to be otherwise eligible to vote. And what's interesting about this case is that Texas takes the position that, hey, look, they didn't do anything wrong by drawing districts based on total population figures, but hey, it's okay to use things other than total population if you want to. And that could be registered voters or citizen voters or eligible voters or whatever. The United States takes the position, the court wants the U.S. to participate, as it frequently does in these voting rights cases, says the plaintiffs are wrong, there's nothing wrong with using total population, and it's really not necessary to decide whether or not alternative measures are okay or not. So the issue that gets teed up is, does the Equal Protection Clause require the state to draw legislative districts with equal populations of eligible voters? And the court's holding, which I quote here, is, look, based on constitutional history and precedent and longstanding practice, a state may draw its legislative districts based on total population, and they don't get to the issue of whether or not alternatives to total population are acceptable or not. The reasoning is really divided into three pieces. First of all, and this is a controversial one, what they call constitutional history. And what they say is, look, under Article 1 of the federal Constitution, seats in the United States House of Representatives are apportioned based on total population. And that there was much debate about this among the founding fathers, and it was decided to base the apportionment of House seats in the U.S. Congress on total population. And that this issue came up again after the Civil War at the time of the consideration and passage of the 14th Amendment. There was debate over whether or not some alternative basis for apportioning House seats should be used, and it was decided once again that House seats should be apportioned based on total population. And then the Supreme Court goes on to quote from the case of Wesbury versus Saunders, which established the one-person, one-vote requirement for congressional districts, and they quote Wesbury for the proposition that equal representation for equal numbers of people is the fundamental goal for the U.S. House of Representatives. Now, here let me break for a second to talk about Justice Alito's concurrence, because the majority responds to that. Alito concurs in the judgment and says he agrees that it's okay to use total population, but he thinks this constitutional history is a bunch of baloney. And his argument is, look, in Reynolds versus Sims, which established the one-person, one-vote standard for state legislative districts, doing for state legislative districts what Wesbury did for congressional districts, Alito says, look, Reynolds versus Sims rejected the so-called federal analogy. Alabama said in the Reynolds case, Alabama was the defendant in the Reynolds case, and they said, hey, look, it's okay to have malapportioned districts with unequal numbers of people, because, hey, the U.S. Senate, senators represent unequal numbers of people. And the Supreme Court said, no, 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 you can't analogize to the federal system, the U.S. system. And so Alito calls out, in Evenwel, calls out the majority for relying on an analogy to the U.S. Constitution and the federal system. Justice Ginsburg's response for the majority is it's okay to use the federal analogy because here the goal is to enhance, not to restrict, representational equality. So there's a debate going on there, and my guess is we haven't heard the last of that debate. Ginsburg then, having discussed the constitutional history, goes on to talk about past decisions, and sure enough, there's a lot of cherry-picked quotes here from both sides. The plaintiffs, the Evenwel plaintiffs say, hey, look, there are all these quotes from past decisions that say that the goal is to make sure that voters have equal amounts of representation. And Ginsburg comes back and says, yeah, but there are also a whole bunch of quotes out there that say that the goal of all this is to have representations for equal numbers of people, regardless of whether or not they're voters. And then the third point of Ginsburg's reasoning for the majority is that the practice has been for years and years and years to use total population as the basis for redistricting, the denominator in the equation, as Rick says. And that basically, if you look at what she calls the settled practice, it's that everybody uses total population, and that it would be crazy to disrupt that. So that's the majority opinion. Justice Thomas has a concurrence in the judgment. He says he agrees with the result, but in a fashion not atypical for Justice Thomas. He questions whether or not you need one person, one vote is in fact should in fact be the law at all. He did a similar thing in a case called Holder a few years ago, questioning whether Section 2 of the Voting Rights Act was in fact constitutional or not. Justice Alito, we've talked about already. He agrees with the result, but disagrees that with the constitutional history point, the notion that the apportionment of House seats in the U.S. Congress supports the result. Let me talk a little bit about the practical implications of Evenwel. The case is pretty straightforward in what it says, but I don't think we've heard the last of this issue. And the reason I say that is this. As in every redistricting case, the plaintiffs have a political motive here. And I don't say that in a disparaging sense. I mean, redistricting is about the allocation of political power, and folks who attack redistricting plans are always doing so for political reasons, and folks who defend them are always doing so for political reasons. And there's nothing wrong with that. But it's important to know what the political motives here are. And Evenwel was the brainchild of Edward Blum, who's brought a number of redistricting cases over the years. And the fact of the matter is, if one were to draw a district based on eligible citizens, that would have dramatic effects on how political power is allocated in Texas. I think it would have the effect of making districts wider, because the eligible there is a greater percentage of Hispanics among the ineligible voter population. Either they're too young to vote, or they're not citizens, or they're not registered, or whatever. So I think it's important to note here that what's going on is a battle that has its origins in the growing Hispanic population of Texas and the growing political power of that population. And I think Evenwel also reflects developments in a couple other areas of redistricting law. As Rick mentioned, the Supreme Court has never really has said that partisan gerrymandering can be unconstitutional, but they really can't. They have been utterly unable to agree on a standard for determining when partisan gerrymandering violates the Constitution. And so what you're really seeing here, I think in Evenwel, is basically a partisan gerrymandering case that's being brought in another guise because the prohibition on partisan gerrymandering has been essentially toothless because the Supreme Court can't agree on a standard. I think another thing that Evenwel reflects is the absence of Section 5 of the Voting Rights Act. As you all know, since the Shelby County versus Holder decision a couple of years ago, there has not been Section 5 enforcement. And what that reflects and how that shows up in Evenwel is this. I think that were Section 5 still alive, there's no way the Justice Department would ever permit any kind of redistricting plan based on eligible citizen voters. And the fact that you don't have Section 5 enforcement anymore because of the Shelby County decision makes cases like Evenwel possible, in my view. Let me say a couple more things about Evenwel. Like I say, I don't think we've seen the last of this issue because the Supreme Court didn't reach the issue of whether or not alternative population bases other than total population were permissible. My guess is that somewhere at some point in the future you will find a state that says they want to redistrict based on something other than total population. And maybe it'll be citizen population, maybe it'll be eligible voter population. I don't know, but my guess is that somebody somewhere is going to come up with a redistricting plan based on something other than total population. That's going to raise a bunch of tricky issues. One, there will be the question of, is this some sort of mask for a racially discriminatory redistricting plan? That'll be one allegation. Another allegation will be about accuracy. It's not at all clear to me that the population figures for eligible voters or registered voters or citizen voters are as accurate as the ones for total population. The Evenwels are saying, well, you really ought to use the ACS American Community Survey, which is an estimate. I'm not at all sure that the Supreme Court's going to allow people to draw districts based on estimates. And I think you'll see some pushback because, as Ginsburg notes, and I think this is really the key to the decision, the settled practice is to use total population. And it's a well-known standard. People know how to get data from the census. They know how to draw districts using that census data. If we went to another population base, I think that would cause all sorts of practical problems. But we'll have to see. Like I said, I don't think we've seen the last of Evenwel or the last of this issue. But those are some of the considerations that could come up. Let me turn now, for just very briefly, to the Whitman case, if I might. And this is another example of a case where there are essentially political motives, and they are masked as presented as a racial gerrymandering case. Okay, this is in essence, Republican congressmen don't like the district court's decision overturning Virginia's congressional redistricting plan. Their concern is if you draw a new redistricting plan, it will make their districts more capital D Democratic, and that will affect them adversely. But the case is litigated as a racial gerrymander. Have too many black voters been packed into a particular congressional district? So anyway, you have a voter challenge to that district, the Virginia Congressional District 3, on the grounds it's an unconstitutional racial gerrymander. These congressmen intervene to defend the plan. The district court strikes down the plan, and the congressmen appeal. The Supreme Court remands it, and we go through another round in the district court where the district court once again strikes down the plan, and the congressmen once again appeal. And the Supreme Court says the issue is, do they have standing to even defend the plan? And they say that they don't. And the reason is one of the congressmen says, well, look, I'd run in the same district anyway. So they say, well, look, this guy has no injury and therefore no standing. And as to the other two congressmen, they say, look, these guys say that they would be hurt by the addition of more Democratic voters to their districts, but we really don't see that they've put up any evidence of that, so they don't have any standing either. I think that this issue is going to come up again. In fact, I think the Supreme Court has already agreed to hear another Virginia racial gerrymandering case. Because you're going to see the Supreme Court is going to have to confront the question ultimately of whether or not black voters were packed into Congressional District 3 and whether or not that does constitute an unconstitutional racial gerrymander. So I think that although the congressmen in Whitman were not successful in getting their claims before the court, this issue comes back as well. So those are my thoughts on Evenwel and Whitman. I think I'll turn it over to Bruce now to talk about the other two cases.
Thank you, Mark, and good afternoon, everybody. And I, too, wanted to thank NCSL, the Legal Center, for having this great opportunity to talk about redistricting today. I have to note that in looking at the folks who are in the chat room, I see a comment that is near and dear to my heart, checking in from the redistricting case hotbed of Arizona. Having been the Voting Rights Act expert for the Commission throughout redistricting and in the three-judge court and the Supreme Court litigation, it would be kind of hard for me to disagree with that. I wanted to, before I get into the slide specifically, to kind of lay the foundation about issues that the cases I'm going to talk about bring up, but more importantly, where we're going in for the next round of redistricting. I had a conversation recently with a city that had contacted me about a mid-decade redistricting, and we talked about two issues that I think are going to become more and more pronounced. Both the issue of what is an unconstitutional political gerrymander and the whole considerations of racial gerrymanders. I know that in some redistricting cases I was involved in Louisiana as an expert for the state, racial gerrymander considerations came up quite prominently. So, and I think in looking at the Harris versus Arizona Independent Redistricting Commission case, looking at the lessons learned from that case and really projecting them forward about where we can go in the next round and what lessons we can take from the tidbits we can glean from the Supreme Court decision are very important. But I think overall there are three primary takeaways from the Harris case. Just like we all learned when we were kids in elementary school, and the teacher said, all right, Bruce, you got the answer right, but you have to show your work. Show your work. Show your work meaning show your work throughout the entire redistricting process. Because as you'll see, the plaintiffs in this case claimed that the Redistricting Commission took politics into consideration unconstitutionally by using the underpopulation of certain districts and overpopulation of certain districts, and then the percentage deviations to suggest that there was some type of unconstitutionality. So, also create a strong record. The record in Arizona, we tried at the insistence of the chair very hard from the beginning to show specifically why changes were being made and why changes were being proposed. Also, as courts have recognized, having objective voices and having objective insight by bringing folks who are experts from the outside really hopes to create that record that the court, in our case, found to be decisive and dispositive. So here, the whole issue of presumptions and assumptions and just suggesting because there is a underpopulation in more districts that elect presumably Democrats and an overpopulation in districts that presumably elect Republicans, that's suggestive of unconstitutionality. As we were preparing for the Supreme Court argument, we talked essentially in the Harris case about, okay, well, where's the beef? Where's the proof that all of this is as unconstitutional as the plaintiffs are suggesting? And that's exactly what the court said. I have to say that as a baseball fan and a baseball coach, I love pitching shutouts, and having a unanimous decision in Harris, and then in the second case I'm going to talk about today, I'm feeling pretty good, certainly also from a baseball perspective. So in Harris, one of the issues was that in the first run-through with the initial plan in redistricting, and this is in the legislative plan, the deviation was a little over 4%. Then, because of issues that came up through the significant levels of analyses that we did, the revised plan had a deviation of 8.8%. And that's what the plaintiff suggested was problematic. Why is there this disparity in the deviation? And that seems to suggest some untoward activity by the commission. So in the forthcoming slides, the information on the screen are all quotations from the court's decision. So in our case, the Section 5 preclearance provisions of the Voting Rights Act were still in effect at the time of redistricting, and DOJ approved our legislative and congressional redistricting plans. So here, as the court really focused on this, and they spent a lot of time on this in oral argument, and they're recognizing, as the slide says, the inherent difficulty of measuring and comparing various factors that may account for small deviations from absolute mathematical equality. Here, the court said, we believe that the attacks on deviation under 10%, so they took this a little further than the suggestion in the Cox versus Larios case out of Georgia. The deviations under 10% will succeed, and those cases challenging those deviations will succeed only rarely in unusual cases. And then Justice Breyer added, and we are not surprised that the appellants have failed to meet their burden here. As Mark and Rick had talked about, the Supreme Court has never set out clear standards about concerning what would be an unconstitutionally partisan redistricting. Frankly, I think we're moving in that direction. As here the court said, even assuming, of course, without deciding that partisanship is an illegitimate redistricting factor, appellants have not carried their burden. So the issue here was a burden of proof issue, that the court decided unanimously that the plaintiffs just had not proven what they alleged to be illegal or unconstitutional in the commission's redistricting plan. Here, it really goes to the key, that the appellants claim that the deviations that I had mentioned earlier, the difference between a 4.0 deviation and an 8.8 deviation across the plan, as well as underpopulation in majority-minority districts and overpopulation in some Republican Anglo districts. So as the court held, the basic claim that these deviations from absolute equality reflect the commission's political efforts to help the Democratic Party. The court disagreed with that, and the court said, we believe that appellants failed to prove this because, as the lower court concluded, the deviations predominantly reflected commission efforts to achieve compliance with the Voting Rights Act and not to secure political advantage for one party. So again, the court looked very significantly, and it came up at oral argument, at the record we created to show this is the direction that we're taking. Compliance with the Voting Rights Act is a significant criterion for the commission, and to the extent there are deviations from absolute population equality, these deviations are done to achieve compliance with the Voting Rights Act in the opinion of the commission. and to receive preclearance on first submission from the Justice Department, which frankly the Commission did. This redistricting was the only time in Arizona history that the state of Arizona had achieved preclearance from the Justice Department on first submission without any rejections or requests for additional information. Interestingly, and that's why I think partisanship is going to be a much bigger issue in the next redistricting than it has been. Raleigh-Wake Citizens Association versus Wake County Board of Elections was decided just a couple of weeks ago by the U.S. Court of Appeals for the Fourth Circuit, citing the Harris case. In this case, the Fourth Circuit decided that redistricting to gain partisan advantage, they found that in this case, and they considered that to be an illegitimate reapportionment factor, deciding that the redistricting plan that was being challenged was unconstitutional. So as you can see in the first paragraph, the Fourth Circuit cites quite approvingly to the Harris decision, and noting that the failure to prevail from the appellant's perspective in the Harris was more an issue of burden of proof, that the record just doesn't reflect what the appellants are claiming. But this is I think this is an incredibly important decision, finding partisanship to be the predominant criterion in this redistricting, and striking the plan, holding that partisanship here that predominated as an illegitimate reapportionment factor. I think this is where redistricting is going, and this is the only Court of Appeals decision that I'm aware of coming after the Harris decision that found partisanship to be an illegitimate factor and to be unconstitutional. Going back to the Harris decision, again, in talking about that underpopulation or overpopulation issue, looking at Democratic-leaning districts being underpopulated and almost all the Republican-leaning districts somewhat overpopulated, according to the Supreme Court. As I said at the bottom of the slide, and that's my language, that's not Justice Breyer, smoke need not lead to fire. Just because there is this difference, underpopulation versus overpopulation, does not by itself create anything that is unconstitutional or legally problematic. And of course, the reason, as the court confirmed in our case, was that we had the record to prove that. So here the court endorsed our efforts, saying that essentially, yeah, the commission acted to comply with the Voting Rights Act. They created these districts in the way they did, and in reliance upon their counsel and their experts and their data and their analyses to create districts tailored to achieve preclearance, which is exactly what we did. And that's, as the court found, as the underlying sentence in the last paragraph, the appellants point to nothing in the record to suggest the contrary. So what's key here, too, is that these decisions were just not made willy-nilly, or they were not made randomly, that we had the record, the analyses, and the data to back them up. From a racial gerrymandering standpoint, as well as a political gerrymandering standpoint, that's really important. Going back briefly to the Alabama Legislative Black Caucus case from last year, 2015, the court found that in that case, and I have a slide for that in a couple of minutes, the court found in that case that the state of Alabama did use, as the court referred to, a mechanical use of numbers to decide arbitrarily, well, this district needs 55% African-American voting age population, while this district needs 65%, without having the analysis to back it up. And that's the key. The court, in very clear language in the Harris case, makes the point very strongly that, as I said at the beginning, do your work, show your work, let the record reflect what it is that you claim that you've done. And that's exactly what the court said in Harris, and that's what we did in redistricting. And here's a couple of slides about the Alabama legislative case. The key is really in the middle, relying heavily upon a mechanically numerical view as to what counts as forbidden retrogression, this being retrogression in the context of Section 5 of the Voting Rights Act. And in the last paragraph, we agree with the United States that a court's analysis insists only that the legislature have a strong basis in evidence in support of the race-based choice or choices that the legislature has made. So clearly, if you're suggesting that certain percentages are needed in certain districts to comply with Section 2 of the Voting Rights Act, for example, you got to have the work, you have to have the analysis, and bringing experts in from the outside who are more objective than the political body, for example, that's doing the redistricting, I think is very important. Moving briefly from Harris to Shapiro versus McManus, and I really love, again, having to talk about a unanimous Supreme Court decision. This case was Justice Scalia announced this decision the day that Harris was argued, and I was really struck by just looking at the demeanor of the justices that I remember thinking, well, this just was a no-brainer for them. And I think that that's true. And the takeaway from this case is shall really means shall. I'm looking at the appointment of a three-judge court to handle cases that challenge the constitutionality of apportionment of congressional districts. In this case, it had been the practice in the Fourth Circuit, which includes Maryland. Trial judges would evaluate on their own whether or not they considered constitutional challenges to congressional redistricting to be essentially good cases, without referring those issues to a three-judge court. And the unanimous Supreme Court, in the opinion by Justice Scalia, said that single district court judges cannot do that. That's the province of the three-judge court, that the judge, the initial judge, district judge, must decide only, is this case a constitutional challenge to a congressional redistricting? And that's it. Once he or she decides that it is, then a three-judge panel is automatically impaneled, and there won't be any dispute to that. So that's really what the court is doing here. Shall means shall. The language of the statute, the section 2284, says that if there is a constitutional challenge to congressional redistricting, it goes to a three-judge court. So, in short, as Justice Scalia wrote, all the district judge must determine is whether the request for three judges is made in a case covered by the statute. No more, no less. And I certainly agree with that. So I think I very much appreciate your time today. This is my contact information, and I'm going to turn it back to my colleagues for possible questions. Thank you.
Thank you, Bruce. So if any of the members of the audience have any questions, please send an email in through the chat box. I noticed that there are a number of comments and introductions, but I don't see any questions yet. But I have one to start out with, and it's really for any of the speakers that want to talk about this topic. I remember, I guess it had probably been about last fall, and the court had already taken a number of redistricting cases, including Evenwel. And there was a feeling, based on the ambitious nature of Evenwel and the ambitious nature of some of the questions presented in the other cases, that this could be a really big term for redistricting. And ultimately, I think the court's decisions were much more modest than expected. Individually and maybe in total. So any thoughts from the speakers on, why the redistricting docket sort of fizzled out?
Well, this is Rick. First thing I'd say is that you have to understand the special nature by which many of these redistricting cases get to the Supreme Court. While most cases get to the Supreme Court on a petition for cert, where when the court decides not to hear the case, it has no precedential value, many, but not all of the redistricting cases make it to the Supreme Court directly from an appeal from a three-judge court. And generally speaking, when the Supreme Court decides not to hear an appeal, it means it agrees that the lower court got the result right. Not necessarily the reasoning, but the result right. And Chief Justice Roberts, Justice Breyer, and others have said they feel a lot of pressure to take cases coming up on appeal because a decision not to do anything is still a decision on the merits. And I think that explains why the court took a case like Evenwel, even though the court in earlier terms had refused to hear cases raising the same legal issue, including a case that Ed Blum had tried to bring a number of years earlier, and only Justice Thomas expressed interest in the case. So while many people were concerned that Evenwel was going to break a lot of new ground, the fact that it came up on appeal, I think, caused the court to take the case and didn't make me as concerned as others. But the other thing I'd point out is there was a recent interview with Justice Ginsburg I think with the AP, the end of last week, where she said that her first draft of Evenwel actually reached the issue of total population being required. And she said she wrote that, it's in her files for if she were queen, this is what things would look like. But since she's not queen, she had to, she was trying to get as many votes as she could for her position, so she took a more modest position. I think that also explains things, especially with the death of Justice Scalia, trying to keep the court's decisions, first of all, avoiding 4-4 ties, but also trying to keep the court's decisions as unanimous as possible. So I think both of those factors explain part of what we saw this term in the redistricting cases.
And I think that's true, Rick. I also think that just as in the Wake County Fourth Circuit decision, in looking at Harris concerning the issue of political gerrymandering, I think if you really parse these cases very closely, and that's aside from people's expectations of what Evenwel could portend, there's a lot in these decisions as takeaways that redistrictors now and in the next round after the 2020 census can really take to heart and use as very instructive bits of advice, going back to what you said earlier, of how to avoid litigation or how to avoid a court overturning their redistricting plans.
Okay, well, the questions are coming in, so I'm going to start asking them. The first one is, did the Equal Protection Clause override the counting of non-citizens, notably slaves, in addressing the number of congressional representatives? That one sounds like it's for you, Mark.
Yeah, that's an Evenwel question. It was interesting. That's a good question because the court kind of notes in passing when they say, well, congressional districts were always based on total population, and there's a little, I can't remember where it is, but a little parenthetical. It says, yeah, even though we only counted slaves as 3/5 of a person. I thought, whoa, that's that was kind of a passing reference to that. So yeah, I think that they really kind of glossed over the counting of non-citizens, notably slaves, in assessing the number of congressional representatives. I think they were talking about the basic principle, and that obviously the Equal Protection Clause, having made freed slaves citizens just like everybody else, now means that the total population requirement would apply completely to apportionment of congressional representatives. So the short answer to Fred's question is yes, the Equal Protection Clause did override that.
Okay, so the next question is, does the panel have anything to say about the Whitford versus Nickel case in the Seventh Circuit?
This is Rick. I can say something. Whitford, like Shapiro versus McManus, is one of these cases that is trying to revive or create a viable partisan gerrymandering claim. Remember that in the Veith case, which was referenced earlier, Justice Kennedy left the issue open as to whether there could be a manageable standard for separating partisan gerrymandering from proper consideration of party in drawing district lines. Both Shapiro versus McManus and the Whitford case, Shapiro from Maryland, Whitford from Wisconsin, are advancing two different theories as to how to put the partisan gerrymandering claim into effect. And in Whitford in particular, the litigants are relying upon an academic theory that's been put forward by Nick Stephanopoulos and Eric McGee, to measure what they call the efficiency gap. They're trying to give a kind of mathematical measure of partisanship that they believe would be useful for courts to decide when there is a partisan gerrymander. In Shapiro versus McManus, they're relying more on something that Justice Kennedy hinted at in that 2004 brief case, the First Amendment right of association and how it might affect one's First Amendment rights if you are stuck in a particular district because you're a member of one party versus another. Both of these cases now, as we heard, before three-judge courts. The trial has been held in Whitford. The theory survived a motion to dismiss, so we're going to get an opinion, and that case, I think, will be on its way to the Supreme Court sometime probably in the middle of the next term, and Shapiro probably not too far behind that.
Okay, next, from Sarah Johnson, how are communities of interest defined in the case law?
Let me answer that briefly, if I could. Communities of interest are often defined by state laws, state constitutions, and that can vary from state to state to the extent of how communities of interest are taken into account in different forms of redistricting. For example, legislative redistricting compared to redistricting judicial districts, that could have some play. So I think looking at how communities of interest have typically been dealt with historically in individual states is one of the prime places to start.
Okay, next question from Wendy Underhill. Can we expect as many SCOTUS cases, I'm assuming redistricting cases, next year? And she asked also if this was a surprisingly high number of redistricting cases.
Well, it's Rick again. Because these cases mostly come up from three-judge courts, I think the court is more likely to take them. However, all bets are off with the vacancy on the court now after the death of Justice Scalia and the uncertainty that surrounds all of that. Part of the reason that the redistricting cases, when they come up, it really depends on the timing of the lower court decisions. I'd point to a Texas redistricting case that's been pending before a three-judge court in San Antonio now for years and years. I think we last heard from that court in 2015 where they said they're working diligently on an opinion. At some point that opinion is going to issue, and I expect whichever side loses that case will be on its way to the Supreme Court. But I do think that there's a real question as to whether or not the court's going to be interested in taking these cases while it has only a complement of 8 justices. It really will depend on the nature of the cases. One thing we've seen is that with the racial gerrymandering cases, you see Justice Kennedy generally siding with the liberals in using these racial gerrymandering cases to police what some see as Republican gerrymanders in these districts, and maybe that trend will continue, and then we wouldn't have the danger of a 4-4 tie in those kinds of cases. And what's pending next year already is a case out of North Carolina and one out of Virginia. So it's at least 2 that are going to be heard next term.
All right, next question from my good friend, Stuart Raphael. Does a holding in Evenwel that states need not apportion based on voting population mean that a vote dilution claim cannot be brought by a voter in one district who complains that another person in his district has been improperly permitted to vote, such as because he is a disenfranchised felon or a non-citizen?
Yeah, I don't think that Evenwel means that. In other words, if you have a situation where I live in District Number 1, and I have evidence that somebody else in District Number 1 has been permitted to vote, even though he's not a citizen, or even though he's a disenfranchised felon. I think I still have the right to complain about that. In other words, because the issue there would be a different issue. It wouldn't be an issue of one person, one vote. It would be an issue of, look, have people been permitted to vote who do not have the right to vote, and has that affected the outcome? I mean, it seems to me that this is sort of like a a ballot box stuffing case or a voter fraud case. And assuming I have the proof, I think I have standing to complain that, hey, that fellow who cast a vote in the same district that I live in was, for whatever reason, not eligible to do so. And so, yeah, I think I would have standing to complain about that.
All right, next question. The Texas Redistricting Challenge is still pending before a three-judge court and is likely to be appealed to the U.S. Supreme Court. I think that was a comment. Sorry. So the last question we have right now, so if anyone else has a question, we still have time for a few more. So feel free to type your question in the chat box. The last question we have right now is, what sort of measures or proof do you think the court would agree to with respect to partisan redistricting? It's a big question.
Yeah, that's an interesting question. I think that in some ways you can answer that by looking at the Fourth Circuit opinion in the Wake County case, where the second redistricting, the redistricting that was overturned, was driven by the Republican-led legislature to create Republican-favored districts. That's in the record, in reading the court decision, that's what the court cited to. And looking back at Harris, for example, while that was the allegation, the Supreme Court said essentially, but the record doesn't show that. So as in the Wake County case, if you have redistricting where the record reveals very clearly that the motivation was to create districts that favored one party over another, just unabashedly, then as the Fourth Circuit said in the Wake County case, that's going to raise constitutional concerns. So I think that goes back to the issue we had talked about earlier. What does your record show? And what do your analyses show to support whatever your eventual conclusion is?
All right, two more questions. I'll piggyback off of Stuart's question. If the person was not eligible to vote at the time of redistricting, but would be eligible to vote at the time of voting, would there still be grounds for a claim?
I think that's going to depend on the state law in the individual state. It depends on how far in advance of the election you have to register and all that kind of stuff. But assuming the person is eligible at the time of voting, I don't think there is grounds for a claim. And again, it's not a redistricting issue at that point. It's an issue of is this person eligible to vote under state law? And if that person is, let's say he was 17 at the time of the redistricting but had turned 18 and was therefore eligible to vote at the time of the election, I think he gets to vote. So I don't think there would be a claim in that situation.
All right, last question. Does the Harris case in Arizona hint at a court tendency to defer more to independent redistricting commissions than it does when the legislature in its entirety is drawing the line?
And I think that that could be true, but I think the larger point is the record. Because as you know, or as you may know, in Arizona, there were a lot of allegations that the Redistricting Commission was a partisan commission. Those are some of the significant allegations by the appellants. But the court disagreed with that and said essentially the record does not support allegations that the redistricting was done here to support one party over the other. So while, sure, I could see that the court tending to favor independent bodies more than legislatures, it still goes to the core issue, what does the record show? What does your work show? What do your analysis show and confirm as far as what the motivations of the redistricting body were?
Okay, with that, it is 1:01, and we are going to wrap up. Rick, Mark, and Bruce, thank you for your time and information. Please register for the SLLC's. Oh, sorry. My other announcement is please register for the SLLC's free Supreme Court review webinar on July 19th. We won't be covering any of these cases except Evenwel in that webinar. If you're interested in further conversations on the legal aspects of redistricting, NCSL will be holding a session at the Legislative Summit in Chicago on August 8th called The Courts Have Ruled, What Does It Mean for Redistricting?, as well as several other redistricting sessions. Check out NCSL's webpage for details on the Legislative Summit. Also, if you're interested in joining NCSL's redistricting email group, please call or email Wendy Underhill. Her contact information is in the chat box, and I'll just go through it quickly. It's wendy.underhill, spelled UNDERHILL, at ncsl.org. And her direct line is 202, I'm sorry, that would be my direct line, 303-856-1379, 303-856-1379. So again, thanks to Mark, Rick, and Bruce, and thank you all for attending, and have a great day.